what is the difference between a judgment and a lien? So a lot of times we, come across judgments on real estate, and sometimes we can assist our clients in selling or purchasing that real estate, even though the judgment exists. And then other times we come across, straight liens against the real estate and we can't do anything. So what is a judgment and what is a lien? So a judgment is an order entered by the court that generally awards some type of money damages to the plaintiff or one of the parties in the lawsuit and against the other party. So if you have a property owner that ends up being sued, they end up losing the case and a judgment's entered against them for some amount of money, then that obligates them by a court order to pay that money to whoever they owe it to under the judgment. Now that judgment, once it's entered, that alone does not create any lien against any real or personal property. It is simply an order by the court basically saying that one party has to pay the other. Then further steps have to be done with that judgment to make it a lien. So at some point, the judgment could become a lien, which a lien is something that basically attaches on to property, and it can be real property or it can be personal property, but basically it grabs onto that and doesn't let go. And in order to convey the property, in order to further encumber the property, that amount that attaches has to be paid. That's really what a lien means, or a lien does. So a judgment alone is not a lien. It just sits there in the court records. And frankly, at that point, it's just a number on a piece of paper or a number in a computer system. Steps have to be taken to then create a lien for that judgment. So one step is to take the judgment and record it in the county recorder's office where the judgment debtor, or the person that owes the money, owns real estate. And so you take it and you record it in the county recorder's office. And then when it's recorded, it can act as a lien on real estate. However, in Arizona and most states, you have what's called a homestead exemption, which basically says that a personal residence of the person that owes money, the judgment debtor, the borrower, the person who the judgment is against, that they have a homestead, and judgments never attach to the homestead. Or if they attach, the owner can sell the property and pocket a certain amount of money without having to pay the judgment. So judgments can be liens against real estate, but they have to be properly recorded against the real estate, or recorded in the county. They're not really recorded against the real estate. They're recorded in the county, and then they attach to any property that the judgment debtor owns within the county where it's recorded. Then the second way you can have a lien by a judgment is actually taking steps to enforce the judgment against personal property. One common example would be somebody has a bank account. And so in order to enforce the judgment against and create a lien against the money being held in a bank account, you actually get a writ of garnishment, and you serve the writ of garnishment on the financial institution where the account is located. And at that point, it creates a lien against any non-exempt amounts. And when I say non-exempt, there is, similar to homestead, amounts that are made available within a bank account that aren't subject to the judgment. But anything above that, it acts as a lien against that, and the bank has to hold those funds. You can't do anything with them. They can't release them. They can't pay checks. They can't do anything. They hold the funds. It's a lien against those funds. And then they eventually pay that money to the judgment creditor after later court proceedings. Another way to create a lien against personal property is to obtain a writ of attachment. And what a writ of attachment says is, oh, well, I know that the judgment debtor has a vehicle, and so or a writ, we call it a writ of attachment before judgment, or a writ of execution after judgment. But you get a writ, and it basically the sheriff serves it on the party may be holding the vehicle, maybe on the judgment debtor, and says, hey, look, this is a non-exempt vehicle. I'm showing up with this writ, and it attaches to your vehicle, and now I'm going to tow the vehicle away and deliver it to the court to be sold to pay the judgment debtor. So that's another way to create the lien. You have to get a writ of some sort to create a lien against personal property. Now, jumping over to liens, there are liens that are created voluntarily all the time. Anytime you go and get a home loan, you give your lender, either, depending on what state you're in, either a mortgage, which is a lien against your home, and that's voluntary, and the homestead doesn't apply to that. You basically say, look, lender, you can have a mortgage against my real estate, or in Arizona and some other states where we use deeds of trust instead of mortgages, you give them a deed of trust. They record the deed of trust against the real estate, and it then acts as a lien against the real estate, not subject to the homestead. But that's a voluntary lien that you give to somebody. And basically, borrowers can, for the most part, give voluntary liens all day long to lenders and others by giving them mortgages or deeds of trust against the real estate. And then there's some other liens that are kind of in between voluntary and involuntary liens. And what I mean by that is liens created by operation of law, such as mechanics liens, where you sign a contract with a contractor and you say, hey, I'm going to pay you. And if I don't pay you, I understand the law provides that they can come and have a lien against my real estate. HOAs have liens. So you buy in a HOA and you don't make your payments. And the documents that you know about, the CC&Rs that you know about when you enter it, says basically that the HOA has a lien against your property. So that's, you're not really signing on the dotted line saying you can have a lien, but when you sign a contract with a contractor, or you enter into an HOA, that they would have a lien against your property if you don't pay. So that's somewhere between, a voluntary lien and involuntary, which involuntary would be a judgment. It's a lien that's allowed and generally not subject to any type of homestead exemption. Property tax liens are another example. You commit to pay property taxes to the, municipality that has jurisdiction over your property. That's another type of lien that can attach. So basically, liens are things that attach to real or personal property and never let go until they're paid. And then judgments are simply an order by the court stating that one party has to pay money to another party.